page 2?
No.
No.
Okay, is there a motion to approve the meeting minutes?
Make motion.
Support.
Motion by Mr. Gleason, supported by Ms. Oparka. All in favor say aye.
Aye.
Opposed? Meeting minutes are approved. Next, I'm sorry, approval of the meeting minutes from the previous meeting. Next item on the agenda is the hearings and reviews. Is there a, let me just say this in. I guess before we get started, I'm going to have to recuse myself on this first case because I was out for this case with the family, death of my family, so I wasn't able to attend that meeting. So unless there's objection on board members, I'd like to recuse myself from this.
No objection.
We don't have to vote on
Okay, I think we probably should, just to make sure it's on the record. Is there somebody who would motion to have me recuse myself from this?
it. I move that Chairman Lytle recuse himself from this meeting.
Support.
Motion by Ms. Torp, supported by Ms. Oparka. All in favor say aye.
Aye.
Opposed? I'll recuse myself from the meeting. I may still be a little bit of a, if something doesn't go quite right, I might jump in occasionally, but I don't think I'll have to. I guess with that, we'll turn over to Rosemary to kind of do the introduction for the meeting, for this first case.
Thank you, Chairman. This is case number 23-00243. Oh, I apologize, that's the case, circuit court case number. I think your ZBA number, do you have the?
1822 ZBA.
18-22 ZBA. This matter was requested to be on the agenda today via a circuit court order in the case 23-00243AA. It was Five Star's appeal of your decision to deny their variance requests for to erect a billboard in the township. The court determined that the ZBA record did not provide enough findings and conclusions for her to make a decision as to whether your decision to deny was supported by competent material and substantial evidence on the record. So she has ordered that this matter come back to you for you to review the matter again and clarify your findings and conclusions as to each variance request of Five Star to erect a billboard in the township. So I suggest that we also clarify again that this is an appeal from the township sign ordinance, which is a regulatory ordinance, and that this board is now charged with applying the standards of review in the regulatory sign ordinance that are set forth in section 72-9 of our sign ordinance, and that in your review you refer to those standards and actually go through all 5 variance requests and make findings and conclusions and motions as to each variance request so that the court is aware of what your findings and conclusions are. Does that make sense?
Yes.
Okay, and then also, just to advise you, you are free to review the original, application by the petitioner, his letter to the Building Board of Appeals, which goes through those standard requirements of 72-9, the planning, the building officials' letter of denial. Those are all things that were part of your record originally. So if you need to reference those, you may do so.
Okay. Okay, well, thank you, Rosemary. Is there, I guess I'll just open up to board members, or should we, Rosemary, should we allow the applicant to speak first, or would?
I don't believe the applicant is present. He advised me that, and I don't see him here today, the attorney advised me that they felt that they would just rest on what they had submitted and,
Okay,
get a copy of the minutes and your decision from tonight.
okay. Okay. With that, I'll open up to board discussion, board members.
I guess for me, I just want to make sure everybody has the appeals procedure from our ordinance that Rosemary suggested we go through with each of the ordinances, or each of the variances, sorry. They are also on page 2 of his letter that he submitted as well. And I printed out a copy for myself, but they're in section 72-9. And it says that at the hearing for an appeal, we may grant a variance from the provisions of the chapter upon finding all of the following are met, and there's A through E. If you want, I can read them off, or if you guys all have them in front of you.
Why don't you go ahead and read those off so that they're in the record?
Okay, so it has to meet all 5 of these. A, the particular physical surroundings, lot shape, and topographical conditions of the property would render compliance with the provisions of this chapter difficult and would likely result in a particular practical difficulty on the owner, as distinguished from inconvenience of meeting the chapter requirements or a desire to increase financial gain or avoid the financial expense of compliance. B, strict enforcement of the provisions of this chapter would serve no useful purpose. C, the type of sign structure and location proposed would not pose a significant risk to the public health, safety, and welfare. D, the benefit of the sign to the general public and/or the applicant under the circumstances outweighs any risk to traffic safety and the township's desire to eliminate the accumulation of visual clutter in accordance with the stated purpose of this chapter. E, a variance would be in the interest of the township and not against the spirit and intent of this chapter.
Okay, thank you, Ms. Aparka.
You're welcome.
Would you like to go through each of those then with the, relative to the case?
Yes.
I believe there's 5 variances.
Mm-hmm.
Should we just start with those? What was the first one, was the 100-foot one?
Yes, the first variance requested is from 72-6E5. No sign or part of sign shall be located within 100 feet of the freeway right-of-way line freeway right-of-way line. And they are, I believe, asking to be 60 feet, correct?
50, or was it 50 or 60 feet? I forget which.
It was less than 100 feet. The site is only 50 feet wide.
Mm-hmm.
Yes. So are you gonna make a motion?
Let's go through that, make sure, is there?
Yeah. Do we wanna go through A through E on each of them, or?
Well, I think you can, you could go through A through E or pick why, the applicant has, indicated to you that, and I don't wanna speak out of turn, that the shape of the parcel is making it practically difficult to meet that particular variance, or that particular, sign requirement, so he's asking for a variance. So I guess you would take what he had presented to you, either in that letter, or if you recall what he had talked about at the meeting, and apply whether you think that a variance from that particular provision would be, you would grant it or not. You're re-reviewing it. Because just recall, at the last board meeting, each variance wasn't discussed individually. So you're kind of re-looking at it and saying, are we gonna grant a variance to subsection 72-6E5 today? Yes or no, and why?
So based on the fact that we're still in open discussion, correct? This would be one that, based upon the shape of the lot itself, I would feel that this would be okay in accepting, and granting a variance, given the fact that the shape of the lot does not allow him to set back 100 foot. And I believe that was his original argument as well.
Okay. I want to discourage the board members from saying, I believe, I think you have to really look at the facts, make sure that.
I believe the facts that he presented in this case do not allow him to set back 100 foot from the freeway right of way.
Okay. And his
And
lot
I
is
think that would be for A.
And his lot is how long, or how wide, we said? 50 feet or 60?
His lot's 50 feet.
50 by 1,000.
Okay.
I think D says the benefit of the sign to the general public and/or applicant under the circumstances outweighs any risk to traffic safety and the township's desire to eliminate the accumulation of visual clutter in accordance with the stated purpose of this chapter. And I agree with you on, the size of the lot and the shape of the lot. But I also feel like, the whole purpose of this ordinance is to avoid visual clutter, and he is leasing the property right now, he doesn't own it, and should another billboard come down in the future, he could reapply for this variance, and at that time, we may grant that. But right
At least
now, another
reconsider.
billboard would still be causing more visual clutter.
Yes, I would agree with that statement as well.
So then, is there a motion this evening?
We need to make a motion on item 1.
Yes.
So I will move to deny the petitioner's request for a variance from section 72-6E5. No sign or part of sign should be located within 100 feet of the freeway right-of-way line based on the following findings of fact. B, strict enforcement of the provisions of this chapter would serve no useful purpose. Does not meet the appeal criteria outlined in 72-9D. The benefit of the sign to the general public and/or applicant under the circumstances outweighs any risk to traffic safety and the township's desire to eliminate the accumulation of visual clutter in accordance with the stated purpose of this chapter. So,
I'll support that motion.
Okay, there's a motion by Mr., sorry.
Mr. Brother.
Mr. Brado, I'm sorry. And then supported by Ms. Oparka. Is there any discussion on the motion this evening? Is there, I guess I'll have Mr. Gleason, would you do the roll call?
Mr. Brado?
Yes.
Ms. Oparka?
Yes.
Mr. Gleason, yes. Ms. Tortle?
Yes.
Okay. So that one is, if I understood correctly, is denied, correct?
Correct.
Okay. Next item, Mr. Parker.
Okay, number 2, which is a variance requested from section 72-6E6. The surface of the billboard or any billboard shall not exceed 300 square feet. Billboards with stacked or tandem faces shall be prohibited.
Okay, board members, is there discussion on that item?
I believe the petitioner is requesting that their billboard be 670 square feet or more. And I believe the ordinance requirement should not exceed 300 square feet.
He's looking for 1,040 square foot variance.
Correct.
And can you provide any factual basis for why he used that variance?
I did not
I
recall hearing it.
I did not see him.
Well, and I'm just gonna offer a suggestion, you might wanna review, again, the reasons stated in his letter as to why he feels that a tandem billboard is warranted and why he needs the extra because of tandem, it would make the sign area more than 300 square feet. I believe he indicated reasons in his letter as to why. You might wanna reiterate those and see if those are justified or not, in your opinion, based on those reviews.
I'm reading the letter right now, and he's saying that, the larger signs are safer because people don't need to strain their eyes or focus longer on smaller signs.
Is he citing cases or any
No,
factual
he
basis?
does not cite any cases or
No studies of any kind.
studies. So there's nothing for us to reference as to where he's come up with these findings.
It's my opinion that a larger sign would be more dangerous and distracting to the drivers.
I would offer just, I'm trying to recuse myself, but I can't do that. Isn't this whole thing based on Lady Bird Johnson back in the sixties, her highway beautification program? I don't know if this is taking off.
I don't know what you're referring to.
Oh, back in the sixties, Lady Bird Johnson wrote actually, her husband passed a law that was to keep billboards off the highways. She didn't like them. I think a lot of this stuff actually has that basis from the 1965 law.
Well, we have our own ordinance.
I'm sorry, I just, okay.
Yeah.
I'll ask to retract all of my comments just now then. I'm sorry, board members.
I think, they're stating this and this with no studies for us to look at. And I also agree that I think a larger sign could be more distracting to drivers. We're not at the illumination part, but I think a larger illuminated sign is more distracting.
So essentially, it's one opinion against
Yes.
another opinion, since there are no studies to back his.
Okay. Any other discussion, board members? Motion this evening?
I will make a motion to deny the petitioner's request for a variance from section 72-6E5, section, the surface the surface of any billboard shall not exceed 300 square feet. Billboards with stacked or tandem faces shall be prohibited. Based on the fact that, it doesn't meet the requirement of not posing a significant risk to public health, safety, and welfare, the board feels a larger sign would be more dangerous and distracting.
I would support that.
Okay, motion by Mrs. Barca, support by Ms. Torp. Any discussion on the motion? Hearing none, Mr. Gleason, do the roll call, please.
Ms. Oparka?
Yes.
Ms. Torp?
Yes.
Mr. Brado?
Yes.
Mr. Gleason, yes.
Okay, thank you. Okay. Let's go to the next one, Ms. Oparka.
That is a variance requested from 72-6E-7. The height of any billboard shall not exceed 25 feet above the grade of ground on which the billboard is affixed. Now, for me, this was the one where I felt like, okay, maybe we could grant that variance because all the other billboards are tall, but I do also not think it agrees with the appeals procedure A that, not A. Look at what this. The benefit of the sign to the general public outweighs the risk of traffic safety or the township's desire to eliminate the accumulation of visual clutter in accordance with the stated purpose of this chapter. And I feel personally, if another billboard came down in the area and this petitioner came back with a variance, that might be one that I would be able to look past.
Okay.
But I do not agree that it does not create more visual clutter in that corridor.
Okay.
Well, once again, he makes the case that the shorter billboards pose a greater danger, but he has no studies to support his position.
Okay.
In our ordinance states that the height of any billboard should not exceed 25 feet, and his billboard is going to be 60 feet above grade. So, for that reason, I have a problem with it.
So it sounds like he hasn't given you any supporting information for his assertion other than just,
An opinion.
yeah. Okay. I forget, did we do a motion yet?
Not yet.
Okay. Is there any other discussion on this item? Is there a motion this evening?
I'm just gonna make one other comment too. I just found a recurring theme in the petitioner's letter is that he had, and he stated here on the record when he was before you guys, that he felt that all of his requests for variances just were going to be in line with what is already there now. Like all the billboards that are there.
Do we have to explore that as like a sixth issue? Or just make sure-
I'm just indicating to you, that's another reason why he had requested these variances.
Yeah, I mean,
Which
That's
is
his reason
why
why.
I keep
You know,
going
I wanna
back,
be
yeah.
in line with every other billboard that's already existing.
Okay,
Which is why I keep going back to that whole criteria that says this ordinance was developed in order to eliminate visual clutter, and we already have 17 billboards. And if you travel north on I-94, as soon as you get out of Harrison Township, it's a relief, since I've been now paying attention to these billboards as I'm driving, it's almost a relief when you get to Chesterfield and you're not suddenly bombarded with all this advertisement.
Yes.
There's 2 in Chesterfield.
And in my
To our
opinion, there's
17.
an ordinance in place, and what has preceded it is not relevant.
correct.
Correct. I agree.
is there any other discussion on that item?
I think we're,
I will make a motion, I'm ready to make a motion, Chairman.
Okay,
I make a motion to decline, or to deny the variance request based upon the fact that the benefit does not outweigh the risk in this particular case to go to a higher billboard.
I'll
Okay.
support that.
Motion by Mr. Gleason, support by Mr. Brado. Any discussion on the motion this evening? Hearing none, board members, I guess, well, Mr. Gleason, will you do the roll call, please?
Yes, Mr. Gleason, yes. Mr. Brado?
Yes.
Ms. Opaparka?
Yes.
Ms. Torp?
Yes.
Okay, thank you. I guess this is the last one?
No.
No, there are
fourth.
2 more.
Oh, I'm sorry.
This one is a variance from section 72-6E11. No billboard should have any movement in any of its parts and shall not contain changing illumination or changing message.
Okay. Discussion this item, board members?
I'm just reviewing the letter to see if he says
Yeah, I'm
anything
trying to see what-
specifically about that
What
one.
point he makes.
I don't believe there are very many already located there with changing messages.
He makes
So
no
it's
case.
not like all the other ones in
Oh,
that
he says it
case.
will be a futuristically invigorating addition to the billboard corridor.
Oh, he says it
Oh,
that.
we're calling it a billboard corridor now. Okay.
He offers no supporting information about that.
No.
Okay.
I will, unless we have any other discussion, I will make a motion
Have
to,
we clarified the item, the issues, is that? And we've said-
I think she will in her motion.
Okay, thank you.
yes. Because I stated it previously when we were talking about this,
Sorry.
but I will make a motion to deny variance from section 72-6E11. No billboard should have any movement in any of its parts and shall not contain changing illumination or changing message, because I find that we find that a changing message would be distraction to drivers and cause more harm to the public. Therefore, it doesn't fall in line with our appeals procedure that the type of sign and structure and location proposed would not pose a significant risk to the public health, safety, and welfare.
I will support that.
Okay, motion by Ms. Opaarka, support by Mrs. Torp. Any discussion on the motion this evening? Hearing none, Mr. Gleason, will you do the roll call, please?
Ms. Opaparka?
Yes.
Ms. Torp?
Yes.
Mr. Brado?
Yes.
Mr. Gleason? Yes.
Okay, very good. And last but not least,
Okay, a motion, a variance from section 72-6E3. No billboard shall be located within 3,000 feet of another billboard based on the ordinance.
okay. Looks like he was claiming he had to be about 1,500 feet, is that what?
He wants a 1,378-foot variance.
So, almost half, or over
Mhm.
half. And I think he has the same argument here that there's nothing else he can do with the property, and the size and shape, that's the only thing that could be put on it. And while I do not disagree with some of that, I do find that the purpose of the sign ordinance was to eliminate / reduce visual clutter. We currently have 17 billboards in this area of the township. Like I already stated, it feels very cluttered when you're driving there. In communities to the north and south, there are billboards, but they are definitely not that close together. And the petitioner is stating that there's already existing billboards that are closer than 3,000 feet from each other, and I don't feel that's a strong enough argument to waive that spacing requirement. Those were installed prior to the adoption of this ordinance. The petitioner also does not own this property, it's just a lease on the property, so he can choose to not release the land if he,
Not renew the lease.
not
It's an
renew the
easement,
lease.
just to make it correct.
What?
He has an easement to use the
Okay,
property.
he has an easement to use the property, so. And also if another billboard were to come down in that area, he could then have an opportunity to come reapply for variances.
So it's not necessarily a permanent denial, it's just until one of those comes down in the future.
If and when.
Yes, yeah. Okay. Any other discussion this item, board members? Is there a motion this evening?
I'll make a motion to deny the petitioner's request for variance from section 72-6E3, which is no billboard shall be located within 3,000 feet of another billboard based on the following findings of fact. Should I reiterate the purpose of the Harrison Township site ordinance?
You could do that.
Is to eliminate and reduce visual clutter. We currently have 17 billboards in this area of the township, and it is very cluttered. In communities to the south and the north, there are billboards, but not that close together. Petitioner stated that there are already existing billboards that are closer than 3,000 feet. This is not a strong enough argument to violate or waive the spacing requirement. Those billboards were installed prior to the adoption of our current sign ordinance. Furthermore, it does not meet the appeal criteria outlined in 72-9D. The benefit of the sign to the general public and/or applicant under these circumstances outweighs any risk to traffic, safety, and the township's desire to eliminate the accumulation of visual clutter in accordance with the stated purpose of this chapter.
Okay,
Nice.
thank you.
It's a lot.
Yes, I support.
Okay, motion by Mr. Brado, support by Mr. Gleason. Any discussion of the motion this evening? Hearing none, Mr. Gleason, will you roll call, please?
Mr. Brado?
Yes.
Mr. Gleason? Yes. Ms. Oparka?
Yes.
Ms. Torp?
Yes.
Okay. I guess, is there any other items that we haven't hit, Rosemary?
I think you covered all the 5 variance requests. Thank you.
Thank you, everyone. Okay, unless there's an objection, we'll close this, our first item, the D1 case this evening, and we'll go to D2. Mr. Gleason, you read the D2 case this evening.
Yes, case number 09-23-ZBA, Carl Capabianco at 41680 Conger Bay, property number 17-12-10-300-002. He's requesting a 15-foot variance from Article 5, Section 14.19 in the waterfront district, where no building or use shall be less than 15 feet from the water's edge. This is for an after the fact covered deck / pavilion.
Okay. Unless there's objection, I would like to recuse myself, if that's a word. And
I'd like to come back.
I want to come back. With that, is there, sir, are you,
Would you like to speak at the podium?
Yeah.
I'm sorry, you got us on a crazy night, so that first kiss is a tough one.
It's not a permanent structure. It's a deck with a pavilion set on it. Now, I was told that, as long as it's not permanently mounted to the ground with a foundation, it's not a problem. DNR said that, fire department's always expected it, said it's fine. It's not a permanent structure, but it's fine. And, you can't, every deck in that area, every deck in every marina in Michigan is on the water's edge of the slip, every single one. To do a 15-foot away from the edge of your slip is kind of insane. You'd be in the middle of the road. So I don't understand what that even means. And then they're saying they have to pour concrete slab in a marina on a slip? What are we talking about? I'm confused.
Okay, well, do you want to, could you just go through what you're actually requesting, make sure that we're all on the same page on this?
I didn't hear that.
Could you go through your case and explain what you're looking to do and just make sure?
Here's what I want. Here's what I've done. First, before I even start building this thing, I built a 16 by 16 deck right on the edge of the, like every other deck in there. And then the wind, okay, I kept on putting up tents and things of nature, and the wind kept blowing them away, blowing them away. I have a 1,000-pound tiki bar sitting on top of that deck. Wind blew that over. So I figured I'll just put a little structure over there to regulate the wind so it doesn't keep blowing my stuff across the country. So I built a structure that I was told, as long as it's not, I didn't put pylons in the ground, didn't fix it to the ground, it's not a permanent structure, I was told. So I did that, and I built it in such a way that the roof is very, very light with light tin with lattice on the edges. So if wind did blow hard enough, the lattice blows open and lets the wind through. Or if it's really, really like tornado type weather, the tin will peel back a little bit, let the wind out. But the structure itself will not move. Framing. I have manufactured structured trusses in there with four, each one has 4 hurricane hangers. I got, on my end pieces where the headers are, I got I have your regular 4x4s going there, plus I have headers on top of that glued and screwed together to double up that header on both front and back. So it's a very, very secure structure, but it's not affixed to the ground. It's that way up on purpose so we can go through it but not lift it.
In your Carl?
Yes.
Okay.
And again, I'm just instead of paying $2,000 a season for a slip, say, you know what, I'll just, because when I first got there, I had, my slip was a pile of rocks and dirt, and nothing more than that. If you've ever been to that marina, kind of like a junkyard, you know, it's horrible. I built the nicest looking thing, best thing in that whole area. It really, everyone remarks about it, it's great, this is wonderful, beautification, it's wonderful, it's what we want to see. And with all the stuff going on in that marina, between the wiring falling in the water and the circuit boards falling off, I'm not sure why this is the main thing. The fire department's already inspected and said, this is nice, they like it, there's no problem. I got a letter, I got the brand, but they got a letter of approval on it, passed their inspection, flying colors.
I'm sorry, the inspection was with who?
Fire department, fire marshal. I didn't ask them, they come, for some reason, they showed up and did it. This thing is in such an area where I have the beach in front of me and a bay behind me, and everyone sees it. It's very highly visible. So everyone wants to make a comment, so I guess the fire marshal just showed up on their own reconnaissance to look it over. They sent me a thing in the mail saying it's fine, it's good. And for some reason, it is, through the fire marshal is approved. And I can show the document if you'd like to, at a later date or whatever.
Do you have copies of it?
I'm, it's the one thing, I grabbed everything but that.
Yes, okay.
So you'll, wish
We'll
I
take
had
your word
it.
for We've seen
But I can't get it though. I mean, it should be on record somewhere in the county. But I can get it, and I can get it. I mean,
Is this
I didn't
structure-
even ask them to do it, they just showed up and did it.
Is this structure something you can remove, or that you would?
I can
remove later?
pull it out of there with, yeah, I can pull it out of there, it's not affixed to the ground.
This would be like, you take it out for the winter, correct?
I could if I wanted to. Can be. I'm not going to, but I could. Matter of fact, the owner, George Lucas, told me if they have a problem with shoring boats, that I'd have to move it if they had a problem with not enough room to shoring boats. I said, yes, I'd do it. If I had to take it out, I'd take it out. So he had no problem with it.
Do you own the slip or do you rent it?
No, this isn't Belmar. No,
sorry?
this isn't Belmar, no, it's not a condo. I just rent.
And then who was it that you spoke to someone, you said about a temporary structure, given that this would be allowable? Who was that you spoke to?
The owner, George Lucas, and his Frank, the guy who actually runs the marina. 'Cause I asked before I did this, so I wouldn't have spent that much money and time building this. I'm not a carpenter, I'm a freaking mechanic. So it wasn't easy for me.
Other questions for the applicant this evening, board members?
I just want to clarify, we are only talking about the 15-foot setback here. We can't do a variance for the building materials, and that's not in our building code.
That was my question too.
Yeah.
Do you have a copy of, does the board have
I
this?
think did I give you a copy of
Yeah.
the tech team?
Yeah,
Okay,
that's
there
why
you
I
go.
want to clarify. This board, we only have the ability to approve or deny the 15-foot setback from the water's edge. It would still have to comply with the,
It would go back to the tech team if you were given,
okay.
whether you approve or deny, it'll go back to the tech.
Well,
team.
And I want to make sure that the petitioner understands that. So
Okay, I do
he can
understand that.
only-
That's why I said there's two different things going on here. You're calling it a permanent structure. It's a permanent structure, it needs to be 15 feet back. It's not a permanent structure if it's just simply a deck. No deck is 15, if I go 15 feet back, if any of the decks go 50 feet back, they're in the road, they're halfway through the road. The deck right next to me is 1/3 this bigger size than mine. So I'm not sure what we're trying to do here. I'm confused.
Well, that's why I was trying to clarify to
I'm
you.
confused.
So what we can do is we can approve or deny your request for that 15-foot setback. Is this okay that I'm explaining this, Chair Lytle?
Yeah. it sounds
Okay,
good.
but we can't say, okay, the structure you have there is okay. You'll have to go back and meet with the tech team, and they're gonna probably
That's fine. I can do
tell
that.
you still, again, that it needs to be on a foundation, and the footers can't be 4x4s, because that's the building code.
Well,
They may, but that's
Yes.
not our place.
But
Okay.
we can't,
okay,
we can't, so if you,
that's fine, I can
if we
discuss it.
approve, you will still have to
That's
go
fine.
back.
I'll do
I just
that.
want you to understand.
I have a backup plan where they told me anything over 122 square feet is considered a permanent structure. My question was, if I have a tent that's more than 122 square feet, is that a permanent structure? Of course it's not. So there's gotta be more to it than just square footage. There's gotta be how you build it, how the structure is and that. There's gotta be more to it than that. So I'll discuss that with them
Okay.
later on.
Yeah, I just wanted to clarify that to you, so that we don't spend a lot of time discussing
Discussing
building
the-
materials and
Yeah.
that, because we just don't have that authority.
I get it.
Mr. Copabianco, I do see on the photograph you gave us, the deck right next to it,
That's big.
to yours, is larger and closer, right?
The other side of that, the chain link fence for a seawall.
I see that.
Any other questions for the applicant? If there's objection, we'll go to board discussion. Thank you, sir.
I do have one.
Oh, go ahead.
Sir, do you plan to remove it for the winter or keep it in place?
I don't want to move it if I don't have to. It's, if the owner needs me to move it, I will. But
Board members, discussion?
I drove through there this evening, just on this strip here, the bay that's shared with Belmare. There are 23 decks / boardwalks that are in this short distance. That doesn't include the Conger Bay side. And I will go with the petitioner to say that his is, I would agree that his is in the best shape. My issue with the 15-foot setback in this particular case is that, because of where the road is in comparison to the shoreline, I believe that's his practical difficulty there.
Because it's dangerous or because of?
No, because he wouldn't,
space.
he would be building into the road.
Yeah, that's a concern.
So are you making a motion?
I would be ready to make a motion.
Okay, go ahead.
Is there any other conversation?
I'd like to just add that I don't know if we want boaters to go over and start using these, creating these permanent spaces like this. I mean, they're either on their boat and they go in the lake or, I guess I kind of look at them as party spaces, and I see some of the ones along, like on South River Road and stuff, coming in. I'm just a little concerned that these become more nuisance. If you want to be on your boat, go on your boat, but you can't get these,
This is, it's inside the marina, not in a public road. You're not gonna drive by it.
no, it's not so much that, it's more of, you have your boat, we want you to go out there and have fun on your boat, but we don't want you to party, have parties without a boat. I'm envisioning people, and I've seen it on the South River side, is that people will come and they have these spaces.
No, that's a different complaint altogether, about my behavior, Party in there, but
Well, I'm
have
just
picnics in there.
saying, we
whole
don't
different
wanna create
complaint.
we don't wanna create these problems for ourselves.
I'm for the marina. If I get out of hand in there, if I start doing what you're saying, they'll throw me out. They've thrown a few people already because it got out of hand.
Okay,
Exactly what you're saying. The marina doesn't allow it. They have their own rules.
okay. Remember, do you wanna make a motion, Sue?
I have a question for Sabrina. Are these other decks that are in this marina, are they permitted structures or are they all?
I would have to look. He did everything without coming to the building department.
Okay,
No permits, no.
I can guarantee you not a single one.
Anything, the other decks, I would have to look into it, I don't know.
I can guarantee you, I watched a bunch of being built, none of them are
Okay,
single.
I'm struggling because it's not, putting a permanent structure on a property that you don't own, you're just renting.
So it's loose laid, it's not
Yes,
permanent.
it functions
Yeah,
as a permanent structure.
Even though it doesn't meet the technical
Yes.
criteria, that's the sense I'm getting.
The 15 feet, yes.
Let me just help you
Go
out
ahead.
just one. He's requesting a 15-foot variance from section 14.19. No building or use shall be less than 15 feet from the water's edge. If you look at your zoning ordinance definition, a building is a structure, either temporary or permanent, having a roof supported by columns or walls for the shelter, support, or enclosure. This shall include tents, awnings, or vehicles situated on private property and used for the purposes of a building, when any portion thereof is completely separated from every other part thereof by division walls from the ground up and without openings. Each portion of such building shall be deemed a separate building. But that's why he's here for a variance, because the tech team felt that this obviously was a building and it's within 15 feet.
Okay.
If the owner were in front of us, I don't think that would make it any different than a lessor of the property. In my opinion, the shoreline here, because it's not protected by a seawall, the functionality of the deck makes it actually safer. If the owner were to come in front of us, I would treat this request the same.
I know about 6 years ago, I had to put in a deck, and it's a 16-foot wooden deck, and I had to go before the Army Corps of Engineers, and I had to get permits from them, I had to get permits from the township, and I had to get permits from the state. And I don't see any of these here, it's a very shortcut process. And I'll admit, a seawall and a deck that I have is a little more scope than what is being shown here. But I think this is abuse of our township ordinances. I won't support it.
Can I give you one bottle of that?
Sir, you're out of order.
Well,
I have the floor, sir.
what do I say?
You've had your opportunity to speak.
Talking now?
Okay. Any other questions?
I would like
Well,
to make.
I think right now you guys have a motion, and did anybody support?
We didn't.
Mr.
I didn't make
There's
a
no
motion.
motion.
He hasn't
Oh,
made a
you
motion.
didn't? I thought you did.
He was
Okay,
going
then
to, and then-
I apologize. If it's just
My
discussion,
concern-
keep going.
My concern is Ms. Davis' definition under the zoning ordinance of a building, temporary or permanent. when I said it feels like a structure, it is,
And I think she
under the
confirmed that.
definition, so I can't support this either.
Okay.
My issue is that this was all done without any permits at all. And we don't have a letter from the owner that says that this is.
There is a letter from the owner.
There is? I didn't see it. There isn't a letter? From the
Letter.
owner of the property that says this
Yeah,
is okay?
yes.
Okay.
George Lucas signed the papers.
You guys saw next week.
Point Mr. Gleason makes is that were the
Oh.
owner standing here, you would treat it the same, correct?
Correct.
Before I built that deck there was nothing but a hole in the chain link. Built it with rock, built the structure, put the structure over so it's safe to walk on, just my ankle on it.
There's no letter, right? Do you see a letter?
Loose laid.
No.
Okay.
I don't see a letter.
You signed the thing I handed you. The letter, even start this process.
Is that the one you said you didn't have?
It's a structure.
Hey, see, did you make a motion?
Go ahead.
Did you make a motion?
You were gonna make a motion or not?
Got it? Okay.
I don't. Oh, this is, I don't believe this is in my packet. Yeah,
It's not in the packet,
I
no.
don't see
No,
it.
it's not in the packet.
You can accept it today.
Can we accept this? Okay.
So you have to go to podium if you're gonna speak. Let's have, you wanna take this?
They improved the
If
property,
you wanna accept it, I'll get it from you later.
improved the property quite a bit from,
To the technical committee.
Okay.
It's not a letter signed.
That was approved by the owner of the property.
Just, he's signing it because he's the owner and he has to, I believe,
Okay.
in order to.
Yeah, in order to file the request for a variance, the owner has to sign the application.
Okay.
But that's not necessarily inferred as approval of the process.
Well, yeah, it is.
It
It's
is.
signing off.
Okay,
He's,
all right.
okaying his request for a variance.
Okay. Thank you.
Okay.
Well, I think I should still make, I think that I'll still make my motion to approve, case number 09-23-ZBA, for the request of a variant, 15-foot variance of Article 14, Section 14.19 in the waterfront district. Given the fact that there's proven practical difficulty here with the shape of, not the shape, but the placement of the driveway in relation to the water line.
Okay, thank you, Mr. Gleason. Support for the motion. Is there support for the motion? Motion dies for lack of support. Is there another motion this evening?
I will make a motion to deny the petitioner's request under, for case number 09-23 ZBA, property located at 17121030002, under ordinance 14-19 waterfront property.
Okay. And is there support for the motion?
Can you say, support the reasons why you're denying it?
The reason
Factual
is the
findings.
zoning ordinance definition of a structure, whether temporary or permanent. This structure meets that criteria and is therefore needs to be 15 feet back. And that's why I am making the motion to deny the variance.
Okay, thank you. Is there support for motion?
I'll support that.
Motion by Ms. Torp, support by Mr. Brado. Any discussion on motion? We kind of did that already. Mr. Gleason, do the roll call, please.
Ms. Twerp?
Yes.
Mr. Brada.
Yes.
Mr. Gleason, no. Ms. Oparka,
Yes.
Mr. Lidle.
Yes. Okay, I'm sorry, sir, your motion was denied.
Can it be appealed?
Yes.
Oh, we'll ask about that. Do that today or
No, why don't you talk,
Circuit Court.
deal with that?
Okay, thank you.
You want your letter back here?
No, why don't you give that to,
Sabrina wants that.
For the
I think
record.
so.
Sabrina has it, it's just the
I do not.
it's the technical committee application.
Oh, that, yes, I thought it was an
Yes,
actual
we
letter.
have that.
I have
We
that.
just didn't get it in our packet.
next
thought it
item on
was an
the
actual-
agenda is the old business. Is there any old business this evening? Okay, I still want to finish my story about Lady Bird Johnson in the sixties. But anyway, new business,
You have to go to circuit court for your attorney.
any announcements this evening? Public comment? Our next meeting will be October 11th, 2023. Motion to adjourn this evening.
So moved.
Support for the motion.
Aye. Or support.
Okay.
Are we-
Motion by,
Support, I'll support it.
motion by Mr. Brada, supported by Ms. Oparka. All in favor, say aye.
Aye.
Opposed? Meeting is adjourned. Thank you, everyone.
If I could just make a comment, some of these are present.